Hello, good morning and welcome to our latest Bristol Life Business Surgery, this time with Burges Salmon. My name is Craig Ingham and thank you very much for joining us this morning. Today's session is all about IP. How can you protect and develop and commercialize your technology, data and IP? We'll be talking with David Varney, Director at Burges Salmon. David is a specialist in the Burges Salmon technology team who advises on a range of data protection, technology, intellectual property, and commercial matters. How can you best protect what you've created? What are the smart ways to develop your IP and how might you commercialize it? And yes, we will also be covering licensing technology, options and strategies, GDPR impacts and practicalities, and a look ahead to the importance of protecting your IP when it comes to exit valuations. Do send your questions and thoughts using the Q&A button below. You can ask anonymously or be named as you like, and please add your company name to your question if so. Note that today's business surgery is being recorded and will be on our Bristol Life YouTube channel later this afternoon. Also look out for Burges Salmon's terrific talk on term sheets for entrepreneurs at EntreConf, our recent entrepreneurs event, and that talk is on the EntreConf site and on the EntreConf channel. There's some really good wisdom there. Firstly, some updates from us. Look out for our next Bristol Life Business Surgery with Anne Hyatt. That's 10th of August. Anne is a former Chief of Staff at Google, worked closely alongside Amazon founder and until last week, boss, Jeff Bezos, in the company's rapid growth days of the early noughties. We'll explore her career during the dot-com crash of 2001 and the parallels that students face now. It's an inspirational piece about career development in the face of apparent, or indeed actual adversity. After this baleful year, what new opportunities might there be? We'll be running further Bristol Life Business Surgeries, these specially curated deep dive sessions showcasing companies and individuals' expertise through discussion. Talk to us about how you might like to be involved if you fancy it. And yeah, they'll be continuing as virtual in the future and will have enduring value via our Bristol Life YouTube channel. Some quite big news on the Bristol Life Awards. The tickets will finally be going on open sale this Friday at midday. The 2021 Bristol Life Awards, which are being held on the 16th of September, which really isn't that far away now at Ashton Gate. They're currently available only to finalists, but from Friday will be on open sale. It'll be a joyous celebratory event, and we've understandably had huge interest in attending. It is great to have the opportunity to bring people together once more. We have a superb roster of sponsors for the awards, led by headliners Marsh Commercial, and Anderson Financial Management, British Corner Shop, Brunel Insurance Brokers, Burston Cook, Curo, Lexus Bristol, SLX, Spaces, Thatchers, Total Produce, BWV, and Bristol Life, and feature sponsors Bristol Sport and Triangle Networks. You'll see from that roster, it's a real gathering of some of the leading businesses in Bristol. That's just the sponsors, and the finalists are quite an extraordinary array of companies. These ones, of course, are the postponed from earlier this year awards, and the Bristol Life Awards 2022 will be held once more in the spring. So if you're an ambitious company or one seeking to rebuild the business pipeline or plain proud to be a leading Bristol company, please do talk to us about sponsorship. It may be a very useful promotional angle for you. Also on the Real Life Awards and activities, the Bristol Property Awards will be running in November 12th, and tickets and tables for those are on sale now. Multiple months of promotion culminating in a lunchtime and afternoon event and many convivial business meetings. It'll be the biggest gathering of property and pro services companies in dozens of moons, basically. Nominations open, deadline for those are the 21st of September. Just a small tease also, later in the year, we'll be running the Big Green Month in Bristol Life and in our similar magazines in Bath, Cardiff and Exeter. And then there'll be, following that, those in November, there'll be a sustainability conference, which we'll be announcing fairly shortly, sort of announcing now, but there you go, in December. The heart of all we do is Bristol Life, and we're proud to publish a magazine that celebrates the very best of the city. We're here to celebrate the good stuff in Bristol, in print, on screen and in person. Thank you for your support. Today then, let's do this. Let's introduce our speaker, and by the power of this Zoom thing, we will have David come forward, David Varney. Good morning, David.
Hi, Greg. Morning, all.
Yeah, morning. Just to set the scene for David, a director in Burges Salmon's technology team, advising on a range of data protection, technology, intellectual property, and commercial matters for clients in sectors ranging from tech to financial services, media, retail, energy, and more. Advised extensively on data protection and GDPR issues, but also advised on tech-related transactions, including the outsourcing and procurement of tech products and services, software development, licensing, e-commerce, digital marketing. David, we're not going to have time for the questions at this rate. You've got such an extensive bio, which is fantastic. Development and exploitation of digital content, and we'll be coming on to that, of course, an extensive experience on commercial intellectual property aspects of corporate transactions, particularly focus on tech sector. David, if we may, let's begin in, dare I say, lawyerly fashion, and let's start with definitions. What is IP?
Sure. So intellectual property is essentially ideas, designs, creativity relating to the products that your company or you're developing. Generally forms into two categories: registered and unregistered. Registered IP obviously has more formal protection around it. That's kind of like patents, trademarks, design rights. Unregistered IP would be things like copyrights, so maybe computer code, unregistered trademarks, like company logos, that kind of thing. But essentially, it's an asset that has value to your business potentially in terms of goodwill and reputation, particularly in terms of logos and trademarks.
When you say has value to your business, I mean, there are multiple aspects. For example, it may be a particular a distinctive piece of code, obviously a logo or a name, but can an aspect of code, a defined piece of code, be part of IP?
Yes, it can. So there's, despite software not being recognised as something that's patentable, you do see quite a lot of patents for computer code. But the most effective form of IP protection for software is copyright, which arises automatically at the point that code is created. The key thing for copyright to exist is that the code has to be original. Obviously, it can't be copied from someone else's code. But yeah, it would attract copyright, and what that would mean would be that if subsequently someone was found to have code that was the same as yours, they'd infringed your copyright, copied your code, and you could sue them for copyright infringement.
And just on perhaps a deeper point in that area, how does the interaction between created code and open source technology work when it comes to either copywriting or IP more generally?
Yeah, so a great point, and something we see actually quite a lot come up in the context of valuations or exits for tech companies, because open source code is something that historically has got investors quite concerned. So open source code is the idea that the code you're using is freely available, and some particular open source licenses say that if you're using that code, it means that the software you incorporate that code into is also subject to those licensing terms, which means that you might use some code in your proprietary software and then unwittingly make it freely available to everyone who uses it, which obviously remove the value in that software product for you. It depends which open source license attaches to the code that you're using. So that's something to be aware of. But historically, we've seen clients use proprietary software, which they own the copyright in, and open source code successfully, as long as those are compartmentalized within their software product. That's something to be aware of, I think, at the outset.
Okay, coming out to the more general points. Can you just briefly explain the different types of different categories of protection, what each level of security brings and why? So the difference in patents, trademarks, copyright.
Yeah, sure. So patents are in respect of inventions, which obviously have to be new and capable of industrial application. Patents are probably the most formal kind of registered IP, and that you have to go through a fairly lengthy process to have a patent awarded in respect of your product. If you have a patent award, it can protect your invention for up to 20 years, subject to the regular payment of top-up fees. And you'll be able to sue anybody who infringes your patent, who does something that your patent covers, for infringement. So effectively, it's the highest form of protection there is, but also the most expensive. And there are a lot of hurdles to jump through in order to obtain the patents.
Could you? I know I'm sure each is bespoke, and it all depends on which jurisdictions and the complexities. But can you give an idea of very roughly the process for the patent and perhaps even the cost as well?
So I should say firstly that Burges Salmon as a law firm, we don't do patent prosecution, it's called applying for patents, but we work closely with third-party patent agents who will do that if anybody wanted any connections. Essentially, what you have to do initially is have an invention, have a bright idea, find a way of describing it, writing it down in a way that delineates clearly what it does and describes the patent well. You have to append that to an application, send it off to the the UK Intellectual Property Office. It can take years for patents to be awarded, but the key date is the date you apply for it, the date you file for it. If you are awarded the patent, that's when your protection will apply from. Fees would vary depending on the complexity of your application. For example, was it only going to be in a particular class? Would it be across different jurisdictions? But a patent registration probably would be in the region of thousands of pounds, probably at least £4,000 to £8,000, I would say. Right,
and trademarking and registering your IP. Talk us through the process.
So trademarking is a bit simpler. So a trademark is respectively a logo, a brand, a slogan, could be a colour that links to your business and your products. As mentioned before, there are unregistered trademarks, which are ones that aren't registered, and you do have some rights in respect to those. In order to protect your trademarks more formally, it's always recommended that you do register them again at the UK Intellectual Property Office. Again, there's a particular form to fill out. You have particular classes as well. If your trademark, it might be a particular service or area or retail sector you operate in that you want to have that trademark existing for. It's going back a few years now, but there was quite a well-known trademark dispute back when Apple, as an Apple Mac, got into music, because obviously Apple Records used to be a big record label who owned the Beatles, that collection. And so there was a lot of furore back in the early 2000s about who owned the Apple mark and how that was going to be allocated between those two entities. But the trademark process, probably a bit cheaper than the patent process, probably more relevant as well to people on this call if they have a logo or a brand they're looking to protect. You can register trademarks in the UK and the EU. Registration lasts for 10 years, but then you can renew it for another 10 years. Again, keep topping it up. That's probably going to be thousands of pounds as well, but I'd say probably less than £5,000, depending on the classes you want to register in.
And when would you advise creators and entrepreneurs, when should they start thinking about their IP strategy?
Yeah, that's a great question. It's never too early to start thinking about it, particularly if you're working in a company that's either in the kind of retail or tech space, in a crowded marketplace, I'd say. If your business relies on a bright idea, then definitely think about patent protection up front. Trademark protection, I would recommend thinking about as you start to get a bit of traction in the marketplace. Obviously, most organizations these days will have done a domain name search before they register their company to make sure that they'll have access to a particular website address. And typically that will be linked to the trademark application, I suggest.
I mean, just on that point, and I'll try to avoid anything personal, though we've had something in our business in this area. What happens when someone has a markedly similar, the same URL essentially, but it may be the .com rather than .co.uk or similar? What rights do you have in terms of trying to seek to argue that there is potential confusion here?
Sure. So there's a crossover here between trademarks and domain names. With domain names, your right of appeal effectively is to the domain name provider. And if your domain name is a trademark, then you have a stronger case, I suppose, to have that person removed from the cyber squatting on your website or using your URL. So there are links there. The recourse, I guess, would be to, as I say, the provider of your domain name, and ultimately, if your trademark was registered, your website address was registered, also to the IPO and the courts.
How does how strong or otherwise is custom and practice, which from a layperson's perspective, if someone has been using a particular brand, whether it's retail, whether it's product, whether it's media or whatever, if they've been using that brand for quite some time and it's out there and known, but there's no legal protection, does any form of custom and practice give you a form of protection?
Yeah, it does, and that's related to unregistered trademarks. So if you can demonstrate you're using a logo or a slogan or a brand name, but haven't registered it, then you do have certain rights in respect to that. If someone did come along and start using it, it would be advantageous, I should say, to have registered that trademark. It gives you stronger rights if you did have to deal with infringement further down the line.
So back to these busy entrepreneurs and creators, if they're bootstrapping their launch or their business and inevitably heavily time constrained, why should they even think about this? And how do you, as an enterprise, get on their radar?
Sure. Again, Greg, good question. So I've as you mentioned in my bio, thank you very much for that, by the way. I've worked quite a lot on successful exits for entrepreneurs where their company is bought up by either private equity house or a large tech provider. One of the key things we see was a difference in valuation at the point of exit based on a company's IP strategy, where, for example, say a founder hasn't assigned their great idea, their patent, their code to the company, where maybe a key developer didn't have a proper employment contract, so he can't be certain that the code resided in the company rather than him. So there are certain kind of pitfalls that organizations can sidestep as they grow, which means basically a more successful exit with a higher valuation. So I would say that tax issues and IP issues are the kind of things that can affect the valuation of the company when it's sold.
And this, over time, has become a more important area than ever previously, partly because I guess the proliferation, well, it's the internet, must have prompted it, but the proliferation of markets, media, routes, etc., meaning that, and the barriers to entry that technology brings, meaning that you can have IP out there, which is, or rather, created IP, which is out there, which is markedly similar to somewhere else, but it requires specialists to guide decision making in terms of protections and thereby value.
Yeah, I think that's right. I mean, one of the key things I do as well actually is work with businesses on licensing their tech and their IP. So that's when you're looking to effectively make money from it pre-sale, where maybe you've got, let's say you're a tech company, you've got software code, and you're looking to get some customers on board. In order to do that, you have to license them the right to use your code, use your product. So we typically do the license agreements there. Depending on the way you craft the license rights, it can be, it's kind of similar between leasehold and freehold on property, in that it can either be absolute ownership effectively, or it can be very, very limited rights to only use your technology, your code, your IP for a very, very particular purpose, subject to payment of particular fees, without the right to transfer it, only use it in the UK with various caveats on it. So that's something else I do, and I'd also urge people listening to think about how they can keep a tighter rein on their IP when they're licensing it.
If, by the way, if anyone's watching thinking, you know, I've never really properly thought about IP in any great detail, a very brief story when many years back when we sold Future to Pearson, and it was quite a chunky deal. Pearson the next week or so came in, and their corporate lawyers, after the deal, said, talk us through your IP strategy. And I tried to bluff my way through it and said, you know what, I actually don't even know what IP stands for. So I suspect the arc of understanding of the complexity and importance of IP as continues to rise, which is why specialists like Burges Salmon are absolutely essential in this process. Can we talk the other way around and talk through an example of where there simply, in your experience with the client, there wasn't adequate protection or possibly any protection? What happened?
Yeah, so we've seen examples there where people haven't kept a tight grip on their IP, and it's kind of leaked out of the business. I guess they haven't registered their IP. They haven't kept a tight grip on how things are being licensed, to the extent that they become quite unattractive to potential investors. Particularly, as I say, in the tech sector, when it's all about your code and your product and your creativity and your IP. If you haven't kept a tight handle on it, then there'll be issues in valuation. So one deal I worked on involved a Somerset-based company that was being acquired by a large US tech giant. The company involved voice recognition software, and one of the issues they'd had was that they'd appointed a couple of developers in South Korea to work on their code. There are issues, firstly, with international labour law, but also to do with IP law under South Korean jurisdiction, because there was the concept that if an individual has developed IP for a business and that IP doesn't have really significant value, then that individual, the inventor, should get a fair share of that value. We have ostensibly a similar right in the UK, but it's been quashed in the courts to a large extent. And so there was a lot of issues around the valuation of that IP and those developers' contribution to the deal, which basically held up the deal initially, and secondly made it fall through because we couldn't work out what the quantum would be of the payment that was due to them. But that, as I say, there was no reason necessarily they had to appoint those developers in Korea. They could have kept it somewhere else with a more favourable IP regime to keep things simplified. So that's just an example of where, I guess, a company not keeping a tight grip and not a tight watch on its IP and how it flows into and flows out of the business has led to issues further down the line.
I guess a related area is the interaction between full-time staff and freelance staff when it comes to tech developers, and where the value subsists. Is it is it in the freelance team, the outsourced team, however defined, who actually do the creating, or is it the brand of the company who've taken the risk to cause that activity to happen? Do you find that interplay from a domestic point of view, let alone internationally?
Yeah, definitely. On that point as well, it's a fairly established point of law as well that if someone's your employee, a full-time employee under a proper employment contract, then the IP they create during their course of employment resides in you, resides in your company. But if you're appointing someone as a third-party contractor, as a consultant, then the situation isn't quite so clear, and it's more likely it will reside with them, unless you have a very specific set of clauses to transfer IP and their products to the company as they're carrying out work. So yeah, that's another point we're thinking about, Craig, actually, in terms of IP protection.
Yeah, and of course, like so much of law, so much of business life, there are, of course, grey areas. I'll give one other short story here, which is that we once had a food magazine entirely rip off, by the way, that's a technical term, not a legal term, the design of one of our magazines. And whilst clearly it was pissing off, it wasn't deemed to be worth the effort to contest passing off. Do you ever find that sort of grey area and you advise, sometimes there's a breach, but it's just not worth fighting?
Yeah, it always depends on the client's appetite to push it. So yeah, another deal we worked on recently was the acquisition of a tech company by an institution in the education sector, and this tech company hadn't thought about its name or its branding or any of those issues, and they'd unwittingly named themselves after a very, very large US organization, and obviously there's a threat further down the line that those two organizations which operate in a similar space would come to an exchange of fiercely expressed opinions, should we say, over the name of the business and the trademark. So we've seen clients where there have been issues there, and also seen issues definitely when things have been sufficiently similar, but clients haven't wanted to progress to the full letter for action or take it further. It would depend as well, I guess, on the kind of sector and the geography. Obviously, you have a relatively set geographical market with your publication. If this magazine was, for example, in Scotland, I can imagine that risk could be abided as opposed to a local competitor.
Yeah, and you've pretty much got the nail on the head there. It was outside of this area, but nonetheless, it was a straight rip. But these things happen. Another one, actually, again in the magazine sector, another magazine actually in this region, not one of ours, has lifted an artist's image for their cover without either requesting or crediting. On a slightly stand-back point, what options might others have in such circumstances where their work has been used as a key part of someone else's offering?
Sure. So there's a few issues there, I guess. So number one would be copyrighting the image. That would belong to the photographer unless they'd assign that copyright to you as part of you acquiring the image to use in the publication. And also the photographer has a moral right to be identified as the creator of that image, because it's copyright work. What that means in practice is that, yeah, you could by all means send a strongly worded letter to that other publication saying you've infringed on copyright in this image, assuming you owned it. We'd like some compensation, or else you could apply to the courts for an injunction to stop them using it. Obviously, that's kind of that's expensive, B, it's really time consuming, and C, it's almost after the horse has bolted if they've already used the image and it's out there and been published. Yeah.
I guess, and then also the issue there and similar areas is demonstrating loss, or that whilst it is a breach, has there actually been financial loss suffered?
That's true. You don't necessarily need to do that in terms of infringements. It's enough that someone's using your copyright and you're not willing them to do so.
Okay, so a question here from Heather McKibben. She said, I designed a pair of shoes using material that is usually used in other garments and products, not patented, but gives a new function to the shoe, better balance. How do I protect that before asking a factory in China to produce a prototype?
Yeah, so good question, Heather. It sounds like there may be grounds for patentability there, so maybe have a look into that. There's also another right I didn't come onto at the top of the call, which is design rights, which is about the way a product kind of looks and feels. Again, those can be registered or unregistered, so you might want to look at registering that. Sending stuff to China, it's changed a bit in recent years, but historically there's kind of horror stories with sending stuff to factories, be built in factories there and getting knockoffs, obviously. So I think you'd also want to look at maybe getting advice from a firm in China. We can help with that if that's needed. We've got lots of best friend firms we work with. But it's about the issue really would be your rights in a jurisdiction where you're having the product made, because that seems to be where the risk is. Obviously, if you're getting it signed and designed and made in the UK, that would be a bit more straightforward in terms of both in terms of the UK law, and also I guess you keep an eye on what's happening in the manufacturing process a bit more easily.
Yeah, you're not quite saying this, but perhaps the answer there might be recognised as a greater cost in producing the prototype in the UK, but there's maybe greater protection. I don't know. Shoes.
More succinct way of saying it, yes, Greg, I agree.
Shoes are not exactly my area, I would say, but I want to talk about somewhere else that's also about as far away from tech IP, but still in the IP world. Which is the infamous cases of Colin the Caterpillar derivatives, the cakes. Most supermarkets seem to have been heavily influenced by Marks and Sparks Colin, allegedly. Again, there seems to be nothing that can be done to protect the IP in that circumstances, notwithstanding it's a cake of an insect or whatever. So IP is but only up to a point?
Yeah, it's interesting you mentioned that. There's a few points come out of that. Firstly, I would suggest that the whole point of this Colin the Caterpillar debate is about publicity and increasing sales. I'm pretty sure it's done. Yeah. Secondly, the interesting thing is it's being presented as this UK massive supermarket M&S against a little challenger, Lidl or Aldi. But in actual fact, if you look at kind of market share and revenue of those supermarkets, I think Aldi dwarfs Marks and Spencer by something 10 or 20 times. But the IP dispute at its heart basically relates to trademarks again, in that M&S has trademarked the shape, the Colin the Caterpillar cake and the packaging and the name. So I think that their case is that Aldi's Cuthbert the Caterpillar, I think it is, looks sufficiently similar to M&S's example to create confusion in the eyes of the public, in the eyes of the user. But as I say, fundamentally, I think it's a plus to run up sales. It's done that very well. The other thing I'd say as well is that both Lidl and Aldi have form in the idea of sailing close to the wind in terms of IP infringements. If you go down their aisles, you'll always see the kind of like leading product and then the very similarly packaged, same colours, same size bottle, same shape bottle, detergent or product that's their own brand as well. So sail close to the wind. I think they've obviously taken good IP advice, because as far as I know, they haven't actually been caught out just yet.
Yeah, the Colin the Caterpillar cake scandal will run on, no doubt. There's a question here from our good friend, anonymous attendee. We have had a web-based product built by a UK-based web developer. we own the IP of the product, or does the developer retain some of the ownership and rights? We touched on this briefly, but perhaps let's amplify that point.
Yeah, hopefully there's an agreement in place between anonymous attendees company and this developer. If there isn't, I suggest that one is put into place retrospectively. That agreement should deal with who owns the IP in the code this developer has written for you. Obviously, you want it to be you. You want him to accept no further payments, waive all further rights in respect of it. Maybe waive his moral rights as well. But the key thing there is making sure that you have a paper trail in respect of any IP that's created for you by an external party. Because if this company does go through funding rounds or is bought or sold further down the line, then those investors in the company are going to want to know that there's a paper trail in respect of IP, and that this UK developer can't turn around further down the line in 5 or 10 years to say, actually, that's my code. You owe me a sizable wedge of money to be able to continue using it.
One response to there, and more generally, is anticipate a problem and deal with it before it becomes, I guess, and have that robust paper trail, as you say.
Exactly.
Yeah. Well, we'll come on to exit planning and, I don't know, Brexit coping shortly, but let's talk about developing and commercializing IP. What's Burges Salmon's role here in that process?
Sure. So as I say, it's about making sure that paper trail exists. So my day job is working with businesses to help them kind of develop, protect, commercialize, license, exploit their technology. Typically, I do that in respect of software and tech companies, but obviously we have a team that does a wider IP as well. And that's about making sure that you think about the terms on which you're licensing your creativity, your productivity, your products to organizations, and making sure you're getting fair value from them. So there are a few commercial things to think about there. Obviously, how much you're getting paid, what are you letting them do with your product, what can't they do with your product, where can they do it, do you want a certain number of people to use it or not, do you want to restrict their ability to use your product to a certain time, like 6 months, a year, 2 years, the kind of parameters around that, like how companies license their technology is where we can add some value in terms of thinking about the contracts and the agreements, and also providing some commercial experience and insights in terms of what's market and what's usual. So I work with a number of startups developing their kind of customer agreements, particularly ones that license software. So their customer agreements and also end user license terms. So when a company is operating in business to business realm, there'll also be some end users who might be customers of that customer or employees of that customer who actually use the software product. So there'll be a set of terms there that also apply. Then there might be things like GDPR issues to think about as well, if it's software or tech that's using cookies or requires a login. We do a lot of website agreements as well, because there's forms of IP on people's websites, obviously, copy text, copywriting the code, images, logos. You want to make sure people aren't abusing those. And so, yeah, where we add value effectively is on those lines, but also our corporate finance colleagues will act on sales and disposals. And as you mentioned in my bio, Greg, we'd help with the aspects of those that related to tech licensing.
I guess, I mean, I'm thinking about another example of an entrepreneur that actually might be quite useful. Is almost like an IP health check. That their business, they felt it would have been hubristic at start, which is literally a bedroom or kitchen table business. Hubristic to imagine international expansion, and so there was no copyright, no understanding, no interest or belief in the American market specifically. They grew to some scale and were ripped off in the States, but the company was one letter different in their URL, but exactly the same offering. And by then it was too late. And so I guess to your point, right at the beginning of this, you said it's never too early to start planning, but somehow to have the remembering to check as you build scale. So you've got to make sure your IP is robust and protected.
Exactly. And I mean, it's even as simple as a quick Google search of a company name should give you what you need. So I have one client that operates in the kind of retail sector, and the initial business name he came up with, if you Googled it threw up some results for like an intimate cream, intimate body parts, which I don't think necessarily is what he wanted when he thought of his company logo.
Well, I'll dodge that one and bring in another comment. This time is from Mia Martel. it's an interesting point about the ownership of content. Again, a number of organizations are collaborating on a creative technology project. Is an SPV the best vehicle to hold any IP rights? And perhaps also explain about an SPV.
Yeah, so that would be a special purpose vehicle that I imagine would be a joint venture between those various collaborating organizations. Good question, Mia. It would depend. It would depend on how your collaboration or joint venture is structured. Is there a dominant party, a dominant partner in that ecosystem, which would be the appropriate organization to hold those rights? If not, then by all means, an SPV is a good idea. Questions I would want to think about at the outset there would be what would happen to that SPV and the IP it holds at the wind down of this creative tech project. What would the SPV be able to do with that IP? What wouldn't it be able to do? What if any partners, for example, wanted to license that tech themselves? How would they be able to do that? You'd want to probably think about a blanket minimum of licensing terms in respect of that tech. One of the things that the questions that always comes up with clients is about jointly held IP. I'd always steer away from that because that effectively means that two people, two parties, two businesses own IP between them. And it always sounds like a quick fix to the kind of situation Mia's talking about here. But in reality, what it means is that neither organisation can do anything without IP without the other party being wholeheartedly behind it. And that sounds at the outset as if that's definitely going to be the case on any projects I've worked on. But then a few months or years down the line, obviously you have differences of opinion. It doesn't always work like that. So I'd always resist jointly held IP. The other thing to think about in collaborations and joint ventures is about foreground and background IP as well. So background.
Yeah, sorry, could you explain? Yeah.
So background IP is going to be IP that each of these partners holds individually themselves as of today. I imagine they're all bringing their own experience, creativity, research, thoughts to this project. And then foreground IP will be anything that's created on this project. It might rely on that background IP, it might not. But you'd want to be clear that each organization, I imagine, held its background IP itself, and then maybe had a right to license this foreground IP from this SPV on fairly reasonable, non-discriminatory terms.
And I mean, so much of law is that old metaphor. It's you're almost negotiating divorce before you've got married, and I guess that's part of your role, is to say, well, of course, it's all beginning fine now, but it may well change. But I guess it's even more. Is it even more complicated when it comes to things like community interest companies and which I don't know if this one is talking about it is that, but collaborative exercises when it comes to creating events or social enterprises and so on. Is IP the same in that environment as it is in straight commercial environments?
Yeah, it is. So a CIC is it's just another form of corporation that can be registered at Company House. It's much the same as a limited company or a PLC. It doesn't attract any particular rules in respect of its treatment of IP that you want to think about. There might be some kind of questions around valuation and charitable valuation to be considered, but legally it wouldn't create too much of a different issue. And in terms of events, one-off events, I guess, to the extent there was logos being created, copied for newsletters, that kind of thing, that would be worth setting up an SPV to hold that IP for. But on an ongoing basis, maybe you'd think about the parent organisation holding that IP on behalf of the company.
But you've touched on licensing a couple of times, so let's talk in a bit more detail about it. How do the specific considerations of licensing differ from the IP needed to execute as a sort of a sole enterprise owner, as it were?
Sure. So let's say I hold some IP, whether that's copyright in an image or some code or a patent. Patent's a good example, actually, because a patent's a monopoly right, and that I can prevent anyone else from using my patent if I so choose. That's what I've gone through the process of the patent application for. That's what I'm paying the patent fees for. But if I own that patent, but you want to use it, I have to grant you a license to use it. A license, effectively, a right to something you wouldn't have a right to do beforehand. So the license I might award you under my patents it might say you have to pay me a license fee, it might not. It might say, if you're incorporating, use my patent to build some kind of products you're selling, I want some royalties, I want a 10 or 20% stake in each of those sales you're making. And I might want you to only use my patent in the UK, so I'm licensing it to someone else in France, for example, or Ireland. I might want you only to use it for 6 months, a year, 5 years, after which time it will come back to me. If you create anything new or interesting about the way of using that technology, I'll want to own that. You're going to give it back to me. That'll be a term of the license. I won't want you to be able to transfer the patent license to anybody else. I want you to come to me for approval before you do that. If your company gets bought, sold, acquired, I want the license to stop because I'm not comfortable with the idea of a competitor of mine having the right to use my technology. So there's a number of kind of nuances you want to think about when you're licensing IP, and that would always vary depending on what the IP was. You probably wouldn't have that long shopping list of items if, for example, you were licensing the right to use an image, I suppose.
Yeah, and I guess in parallel might be franchising, where it's an even more sort of tighter geographic limit, but essentially the same sort of precepts and principles apply.
Yeah, yes, exactly.
Yeah. Come on to exit planning. It's a fantastically dumb question, but I'll ask it anyway. How important or valuable is protecting your IP when it comes to a sale? Sure.
Well, yeah, as I mentioned, I've seen a few issues or hiccups occur where companies haven't paid sufficient attention to their IP strategy and policies as they've scaled. And so it is one of the things that affects valuation, particularly because for an emerging company, the key things it's going to have that an acquirer is going to be interested in, particularly a trade acquirer, a company that wants to continue to build that and use it in its own business rather than for private equity purposes. It's going to be looking at its people, its customer base, and its intellectual property. So those are going to be the key things you want to make sure you've got covered and have all your paperwork done and your homework in place for before you go to the market in respect of the sale. So as I've said, the kind of things I want to think about there would be like an internal IP policy. So me as example, if we talk about JVs or collaborative project, I want to make sure that the companies there have an IP policy in place, which says that their employees know to report any new inventions they might create, to help the company register any IP at the IPO, not to leak confidential information, which is something I haven't spoken about actually, confidential information, which isn't really a form of IP per se, but still something that you should keep close to your chest. Information about your business, your products, your ideas, you want to keep those secrets. And as I say, prevent the kind of leaking of IP out of your business, because that's going to affect your valuation.
Have you got examples of where you can determine if it's actually value accretive? I can see it's value destructive if you haven't got the requisite IP standards in place. But are there times when a buyer will determine specific extra value because of the robustness of the protection?
Yeah, so an example of that, I guess, is trademarks, which attract goodwill, and that's always quantified in the context of a sale. So it might be like the Caterpillar example. If someone was to buy Marks and Spencer, there would be a certain amount of goodwill attached to the recognition of the Caterpillar trademark product. So it does attract value. It's always hard to define what that value is without having a kind of third-party IP consultant lined up to tell you about the marketplace and how your product differs from others. And again, that's where we work with consultants to help clients with that stage of the transaction. But in terms of specific examples, I've definitely seen companies been attractive as targets because of their patents, their ideas, their technology. So the example I spoke about earlier about the education client of ours that acquired a tech startup, that was because this tech startup had a great idea. They built a great platform that our client wanted to partake in, and it would be much easier for our clients to buy this business than it would be to develop the business from scratch themselves, the idea from scratch. So there definitely is value attached to IP, yes.
And I guess at a, dare I say, intangible level, the sense of reassurance of a well-run company that it's a form of due diligence in a sense, that this has been anticipated, it's thereby a more robust company. It signals that this is a sensible enterprise, I guess.
Exactly. I mean, one of the key things that an acquirer would look at when businesses come to sell will be stuff like as you say, their board minutes, have they been run properly, directors' agreements, employment contracts, they're all in place and well adjusted. But the other key thing is the licensing. So on what terms have organisations given away or licensed their IP, and have they sold it too cheaply? Those would be the key things any inquirer is looking to answer.
Here's a bit of a cri de coeur. You can only imagine how much angst lurks behind this question, inevitably from an anonymous attendee. How do I persuade my co-founder that protecting our IP is a necessity rather than an expensive option? We own a fintech startup.
So I would say initially, obviously, fintech's a very, very crowded marketplace. The IP that I'd be thinking about there would be firstly, as I say, branding, so logos, trademarks, that kind of stuff, but more fundamentally, code, software code. So when you're talking about protecting your IP, I'd want you to make sure that all the code that's been developed for you, unless you've done it yourself, you two co-founders, that will reside in your company, in your business, and isn't, as I mentioned before, left with the developer, which would then create issues further down the line. If you've got a whizzy way of doing something fintech related, maybe think about, does it qualify for patents? That might be a bit more tenuous, but the key things to think about are going to be copyrights and trademarks. And the way you should persuade your co-founder, as I've mentioned, it's going to affect the valuation of your business further down the line. You're operating in a very crowded marketplace in the fintech area. It's very competitive. There's lots of companies doing similar things. You want to make sure that what made you unique, or USPs, were protected in order that you could commoditize and get a good value on those further down the line. We've also got a great fintech practice at our firm, so any questions, do please get in touch. Do
beat a path, but the underlying point there is absolutely it's in your self-interest, in your co-founder's self-interest, so to do. A different form of valuation, perhaps a slightly more abstruse financial one, is when it comes to balance sheets, that brands can be deemed as intangible assets on a balance sheet. Perhaps not if it's the sun. I saw that as marked down to 0 value as a brand, but there you go. Other brands do have value. But what about IP and specifically tech? Can they deemed to be assets from a balance sheet perspective?
Yeah, they can. So there'll be value attached to patents, to trademarks, the Goodwill I mentioned before. Tech, so licensing tech will represent an asset on a balance sheet to the extent that it derives customer revenue. That's how I think I'd interpret that. So there is always going to be value in your technology as long as you're protecting it correctly and licensing it appropriately.
Okay, let's come on to the joys of Brexit, and how has that affected IP yet? Or, I mean, are there any specifically different legal requirements, or is it? I mean, I've read a piece that it's about the European Patent Office isn't part of the EU, so therefore IP is fundamentally not affected. True or false?
So yeah, the European Patent Office is a separate layer, I guess, of European bureaucracy to the EU. There are a number of issues in respect of EU enforcement of UK IP now. We can advise on that. It's getting more and more complicated. We have an office in Dublin as well, which deals with our EU filings as well now.
So when you say it's getting more complicated, perhaps giving it an indication of that, is that something which is live now, or is coming up?
So that's been an issue since Brexit, I think, in terms of enforcing. So previously, if you had a UK patent and you were seeking to enforce that in the EU, it'd be a lot simpler than it is now. Now, I think you probably have to go through a couple more intermediate steps. We've got a great IP disputes team as well, who advise on these kind of issues more regularly than I do. So if anyone did have any queries about that, very happy to pass those on. But in terms of Brexit and my workload, we've seen a lot around data protection. There's been a lot of issues around that. And data obviously is another form of IP that it's an asset that needs to be protected. There's been various issues in respect of the UK's data protection regime, both leading up to and following Brexit, also in respect of quite a few different cases from Europe, and some political ramifications from the US, which made it quite complex. So I would say if you're a business that's relying on personal data about individuals, and you're sending that internationally or doing something complex with it, maybe this fintech startup is doing something clever with people's bank transfers, for example, or bank account histories. then I'd say that's another set of issues you want to think about, making sure that you're both data protection and GDPR compliant.
Okay, and when you look out at the vista of forthcoming legislation or legislation being enacted, is there anything on that time horizon from an EU perspective that companies ought to be considering now?
Not that I'm aware of. I mean, in the wider scheme of things, there's been noise for about 10 or 15 years about an overhaul of the patent system, because like most things in law, it still seems to be based on something from the 1870s. So maybe that will be overhauled at some point in the next few years to make it fit for a digital age. What I would say, arguably, is that having left the EU, if we were to overhaul that system in the UK, it should be a lot simpler than it would have been beforehand, where we had to take the needs of the other 27 member states into account. So that's maybe something to look out for, but that's kind of like fairly long term. There's no other kind of big shakeups that I'd be aware of. At the moment, there's a few cases going through the courts in respect of trademark infringement, the kind of things courts will look at. We do quite a good newsletter on that as well, so if you're interested in that, sign up for that as well.
You're hitting all the right spots. I'm quite impressed. Very good. Let's come on to from Brexit to GDPR. Clearly, there's much hiatus in the run-up to May 2018, and there was one perhaps slightly cynical view at the time that GDPR was the millennium bug du jour. But what has actually changed in practice?
So what I would say is that the legislation before GDPR was based on the 1996 European directive, which effectively predates the internet pretty much. So what GDPR has done is it's brought data protection into the digital age. I tell my clients it's really set up to target the kind of large monopolistic West Coast US tech companies that bureaucrats in the EU don't like very much. But everyone has been caught in the net. So the key thing GDPR, obviously everyone's aware, I'm sure, of the fines. Previously, the largest fine you could be hit with for breach of data protection law was £500,000. Now it's up to €20 million, £17 million, or 4% of global turnover, whichever's higher. We haven't seen any fees yet, any fines yet in that level. British Airways was threatened with the ICO, the Information Commission Office, the UK Data Protection Watchdog, to be fined with a fine approaching £200 million for historic data breach. In the end, the ICO fined them 20 million, so that's a bit of a climb down. Similarly, the ICO threatened to fine Marriott Hotels, I think 187 million, but they fined them 17 in the long run. So there's big numbers floating around. So far, they've been negotiated down effectively by the companies that are being hit with these fines. But I suspect that at some point we'll see a kind of 7 or 9 figure fine in the UK. Other regulators around Europe being much hotter than we are on this. So the French regulator Sunil has fined Google quite a few times already for GDPR breaches. And the most recent one was €50 million. The Italian regulator, I think they fined Vodafone. The German regulators are also quite hot, and they'll issue fines a lot more easily than within the UK. The other thing to be aware of under GDPR are that individuals have more rights and much more aware now of their data rights. I'm dealing with a client this morning who's had a letter and demand for payment from a client in respect to their cookies policy. So there are more ways for organisations to slip up, is what I would say, is what GDPR.
And presumably there's now more case law emerging where there's been precedent established of proof of breach or whatever.
I wish I could say yes, Greg, but I wish I could say yes, but actually the ICO has been blindsided a bit by Brexit. That's taken up a lot of their resource over the last 4 or 5 years. And so we haven't actually done too much work enforcing GDPR yet. So we're still kind of waiting to see how hard they'll play ball, I suppose.
So the Brexit shoe is still to fall. Sorry, the GDPR shoe.
Potentially, yes.
Yeah, that's something to look forward to, isn't it? But coming back to your earlier discussion about exit planning, are you finding that there are some clients who are still not compliant 3 years on with GDPR, and yet they're having to sort of retrofit a data strategy?
Yeah, we do that all the time. So there's a few things we can do depending on client appetite. Either go and do a forensic analysis of what they're doing with data, how to use it effectively, or the other option, the other end of the spectrum, I guess, is a light touch approach, just helping clients think about data, make sure they're doing things properly, and think about best practice. At least they know what it is and the kind of things they should be looking out for.
Good. There's a promising line here from an anonymous attendee, which I think we'll probably both quite like. I attended EntreConf, which we were very pleased to put on recently, and was impressed by the clarity of your term sheet presentation. That's Burges Salmon's term sheet presentation. As an entrepreneur, business life can be quite chaotic. How and when can you help bring the clarity and simplicity to a disruptor who's perhaps not linear in its growth trajectory?
Sure. So it's my colleague Alex Lloyd, who sits on the corporate finance team, who did the term sheet presentation. I'll feed it back to him. I'm sure he'll be very happy with that review. So yes, we recognise business life can be quite chaotic. We work a lot with emerging companies, startups and scale-ups, particularly in the tech sector. We have a good track record of clients in that space, particularly in the Southwest. We work both with companies, also their investors. We work a lot with private equity houses, venture capital organizations looking to invest in tech companies. And you're right, it can be chaotic. I think the key thing that entrepreneurs want to know is that they have someone at their shoulder that they can turn to for advice at the appropriate time. And that's very much something that we would see ourselves doing at BS. We're interested in companies in this space to become that strategic long-term partner, to help grow with your organizations. And so I think it's about knowing that someone who can pick up the phone to. If it's a question along the lines of, I've got a presentation tomorrow with a potential investor, or I'm having a chat with a potential customer, they've got these issues, kind of bounce some ideas off you. That's the kind of service that me and my colleagues are happy to provide. I'm sensing also in this question there's something about fee rates. So BS also, Burges Salmon also operates, obviously, our kind of established client base is like the FTSE 250, so large organizations. We do a lot of work internationally, do a lot of public sector work as well. We do offer competitive pricing to select clients in the startup and scale-up space, as I say. We try and do it on the basis of fixed fees mostly, in that we give people certainty of what advice they were getting and how much it was going to cost them. But as I said, we'd want to grow with them. So it would be about maybe us taking a hit or giving a deep discount on work initially, and then seeing how things progress over the first kind of like year, 18 months, 2 years as a company moves and scaled.
Yeah, it's again, words in your mouth, but it's I guess it's about taking a view on the opportunity that such entrepreneurs, fast growth entrepreneurs present. As we had at EntreConf, we had the top 50, they're meant to be top 30, but top 50 most interesting entrepreneurial businesses in EntreLeague, as chosen by a panel of experts. And there was just a proliferation of just incredible businesses, some of whom I personally hadn't heard of, but they are the absolute stars of tomorrow, some already stars of today. Talking of timing matters, we've got a minute or so left. It's flown by, David. I found this absolutely fascinating discussion, and thanks for your time. And
thanks for having me.
Yeah, but I wondered, as a sort of a closing point, just to perhaps nutshell up, if that's a term, probably not a legal term, some of your thinking this morning, some final top tips on IP for those watching today.
Sure. So I would say it's never too early to start thinking about it. As I mentioned, even if it's just a Google search of a potential name for your company, to make sure you're not treading on toes, so to speak, and it's a clear space in which you operate. Make sure that any code IP that's created before you establish your company is transferred from you and your co-founders to that organization. We can help with that. Make sure that any developers you might appoint, also you have a contract in place with them, which makes it clear that you own the IP they create for you. Think about strategically about where you're licensing your IP, who you're giving it to, on what terms you're giving it, what rights you have under that contract. And as I say, make sure your IP is as tight as possible. When it comes to exit or valuation, things hopefully be looking quite rosy.
Really good indeed. Well, thank you very much to David Varney of Burges Salmon for this business surgery. I hope it's been useful. I've certainly found it fascinating. Thank you for everyone watching now and subsequently on YouTube. Do when it's published on YouTube, and I'm sure this isn't a breach of our IP, it isn't at all. Please do share that, because there are some great insights here. And there's been some terrific questions as well. So thank you very much. And to David, on your behalf, thank you.
Thank you.
Thank you also, everyone, for your support for Bristol Life. It is appreciated. And do look out for those Bristol Life Awards tickets going on sale this Friday. From Bristol Life, good luck to you all in the coming months. This has been a Media Clash production, and this has been our latest Bristol Life Business Surgery. Thank you. Bristol together, always. Thank you.